Accountability, and responsibility for ensuring access to, promoting equity in, and improving the quality of basic education as pursued in our sulong edukalidad. Now, whether as workers in DepEd or as students once upon a time, we are all aware of how important learning resources are to basic education. These learning resources are fruits of creativity. They are products of the mind of one or more persons. They are intellectual properties. In protecting and promoting the right to accessible quality education, the 1987 Constitution and the Intellectual Property Code of the Philippines prescribe the state to embrace a human and social development thrust on the use of intellectual property. So please listen to this carefully. The 1987 Constitution provides in Article 12, Section 6, the use of property bears a social function, and all economic agents shall contribute to the common good. Now, aligned with that provision of the 1987 Constitution, the Declaration of State Policy in the Intellectual Property Code of the Philippines reads, the state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensures market access for our products. Therefore, it shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in this Act. But there is a second paragraph to that declaration of policy, and this is the very important second paragraph. The use of intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress and the common good. So that second paragraph borrows the words of our highest law, the 1987 Constitution. That declaration of state policy in the Intellectual Property Code manifests the recognition of the need to balance. No? There's a need to balance the two primary interests at play in the intellectual property system: the promotion of creative activity and exclusive rights, such as copyright under the first paragraph, which I read, and on the other hand, the social function of intellectual property anchored on the right of all people to human dignity, human development, and the promotion of the common good. So, to this end, there are also exceptions or limitations to copyright, as our able resource speakers will explain to you shortly. For instance, though, very briefly, as an exception to copyright, the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled allows the not for profit use and conversion of copyrighted materials to accessible formats like Braille. And listen to this, without permission from and without payment of royalty fees to the copyright holders, provided the conditions are met. So that's an example of a limitation to copyright. The DepEd strongly supported the accession of the Philippines to this Marrakesh Treaty, which took effect in the Philippines in March of 2019. A sound and relevant intellectual property framework that would lead to national and human development should stimulate innovation and creativity of writers, authors, inventors, and creators in general, and protect ownership of such property, but while also allowing equitable access to intellectual property highly necessary in a developing country like the Philippines. Inclusive growth, which lies at the heart of the Philippine Development Plan, can be facilitated very much so by intellectual property, not only through promotion and protection of the creativity and products of creators, but also through information, education, and empowerment of a knowledgeable people. The necessity and significant contribution of intellectual property to the education sector, particularly in relation to DepEd's delivery of basic education services, cannot be overemphasized. For this reason, knowledge on copyright for the proper creation, reproduction, derivation, and use of intellectual property is necessary as we implement the K-12 program and use learning resources in print and multimedia format in various platforms, in different mother tongues and adaptations, and in accessible formats for learners with disabilities, such as Braille. Under the K-12 program, our learners are encouraged to develop critical and creative thinking as part of their 21st century skills, and in the process, they also produce intellectual property. Our teachers and personnel themselves produce intellectual property as they engage in the practice of their profession. These endeavors and activities involve matters of copyright. And so I hope this webinar will be very much of help to you and you will make use of what you have learned here. So let me end by saying that every child deserves an opportunity for lifelong learning. Inasmuch as Henry Adams said that a teacher affects eternity, for he can never tell where his or her influence stops, we cannot also tell where the wonders of learning by using and creating intellectual properties may lead. One child, one teacher, one book, and one pen can change the world, in the words of Malala. And that is true whether we are under normal times or in this extraordinary time of the COVID-19 pandemic. Maraming salamat po at muli magandang hapon po sa ating lahat.
Maraming salamat po, Yusek Joe, for enlightening us on the different considerations and legal implications to the production of learning resources, and of course, for contextualizing the topic of intellectual property to our work in the education sector. As a former teacher myself, I can attest that the very critical are learning resources to the education of our young, and they are as integral to our educational system as the teachers are. I'm sure after the message of Yusek Joe, we're all excited to listen to the presentations of our speakers. But at this point, as a form of a diagnostic exam to assess what our participants' knowledge of copyright and other related art rights are, we will have a simple activity po. All you need is your laptop or your mobile devices, a decent internet connection, and of course, a little competitiveness in there too. So if we could flash po the platform where we will facilitate the game. So for this activity, we will need you to go to the website menti.com, that's menti.com, to answer several questions, enter the code given, and answer several questions. This will also help our speakers assess what they need to focus on, what they need to just do discuss in passing for the rest of the afternoon. The code is 223429. 223429. We will just be giving you a specific amount of time to answer the questions. Then we will give the final answers. The correct answers, I mean. So for the first, it is a legal term used to describe the rights that creators have over their literary and artistic works. And we have 112 responses, 116 in running. And I believe that is enough time. The correct answer is, of course, copyright. So we have basically the 100% of our active attendees answering the right question. So I guess we can move to the next question now. So next question, works as covered by copyright are classified into two categories, and these are, let us see. Again, blank or original intellectual creations in the literary and artistic domain protected from the moment of their creation. This should be easy for attendees of the first seminar. There you go. We have a new code, by the way, that is 969846. Again, the new code is 969846.
Say the words before you don't feel right. What do you expect me to say? Now it's just a little too late. You take my hand and you say change. But boy, you know you're begging, don't fool me. Because to you, it's just a game. Now it's just a little too late. So let me on down. 'Cause time has made me strong. I'm starting to move on. I'm gonna say this now. Your chance is come and gone, and you know you said it's a little too late, a little too wrong, and I can't wait for you to know all the right things to say. You know it's just a little too late. You say you treat my mind face, but you don't like me. You just ain't gonna change. So be real, it doesn't matter anyway. You know it's just a little too late. Yeah, yeah. It's too little too late. Mm-hmm. I was young and in love, gave you everything, but there wasn't enough. Now you wanna communicate. No, it's too little too late. Go by someone else. They're letting you go. I'm loving myself. You got a problem, but don't come asking me for help. 'Cause you know you said it's a little too late, a little too wrong, and I can't wait for you to know all the right things to say. You know it's just a little too late. You say you dream of my face, but you don't like me. You just ain't gonna change. So be real, it doesn't matter anyway. And you know I can love with all of my heart, baby.
Let's just wait for more responses to come in before we declare the correct answer. I guess that's enough time. And again, the overwhelming majority is the correct answer. The correct answer is original. So we can move now to the next question. Option, derivative works. So more or less, we saw that our participants already have an idea of the basics of copyright and related rights. And with that, we are already confident that we can now proceed to our presentations. But before I turn you over to our first presenter, here are a few reminders again. First, you need not take photos or screenshots of the presentations, for they will be made available to you through the emails you provided. Second, we'd love to hear from you during today's presentation. Should you have questions, and many are already coming in, please feel free to send them through the questions tab visible at the left side, your right side of your screens. In the interest of time, we will filter questions to that within the coverage of the webinar topic only. Our speakers will be answering questions after the last presentation. Third, again, certificates of participation will be issued after day 2 in accordance with guidelines mentioned by Sir Jejumar earlier. So please make sure to fully attend both days of the webinar to get your certificate of participation. And lastly, your feedback matters to us. Please take note of any comments or observations that you may have. We will be sending the link to the evaluation forms on day 2. And seeing that we are all set, I will now introduce our first speaker. Our first presenter is the Chief of the Accreditation and Standards Division of the Bureau of Copyright and Other Related Rights. He holds a Bachelor of Laws degree from the Lyceum of the Philippines University and a Bachelor of Arts in Philosophy from prior to his joining the IPOPhil. He was the head of the Adjudication Division of the Commission on Audit Corporate Government Sector Cluster 4. Here to give us a discussion on exceptions and limitations concerning fair use, we have Attorney Jeremy John C. Bayaras.
Hello.
Audible po, sir.
All right. Yes, good afternoon. Good afternoon, everyone. Andito na naman ulit ang IPOPhil. I was supposed to be the second speaker, but medyo may technical difficulties tayo. So I will begin with a quick review of the fair use doctrine, which was first introduced to you by our director, Director Cuyo. And this is one of the limitations, of course, one of the limitations to copyright. The limitations include like the exclusion of some subject matters from the coverage of the copyright law. For example, the ideas, for example, and also government works. These are not covered by the copyright law. And one of the limitations also is the fair use doctrine. But before we can talk about fair use, it's important for us to be reminded once again of what are the protections, of the protections provided by law for copyright holders. And, okay, nakita nyo na to the first time I presented about copyright law. And of course, these are the exclusive rights granted to copyright holders. They are economic rights and moral rights. All right, so let's have a review of the economic rights of a copyright holder. Here they are. There are seven economic rights. And may nilagay ako dyan, R2D2 PAC. It's a mnemonic, I think. Or it's something that will make you remember easier the economic rights of a copyright holder. They include 2 R's, 2 D's, P, A, and C. So the 2 R's are the right of reproduction and the right of rental. The 2 D's are the right of first public distribution and the right to public display. Letter P for performance, A for adaptation, and C for communication to the public. So R2D2 PAC are the economic rights of a copyright holder. So let's go through them one by one. The exclusive right of reproduction includes, of course, refers to the right of the person, to the creator and author, to reproduce his work. You know, copyright comes from the Latin word copia, which means not just to copy, but also to make plenty. So basically, copyright is the right of a person to make plenty his work, so to reproduce his work. So if you look at the different rights, economic rights of a copyright holder, you will see that basically it's just the right of reproduction in different forms. So as you can see, the first exclusive right of a copyright holder is the right of reproduction. So this reproduction also, according to section 177.1 of the copyright law, states that this right to reproduce does not mean that he has to reproduce the entire work. If he can choose to just reproduce a substantial portion of his work. All right, let's go to the second economic right. The second economic right is the right of adaptation. Well, this refers to derivative works. Medyo natanong to sa question kanina sa Menti. So I think most of you already know that derivative works refer to those works that were derived from an original work. For example, the dramatization of a novel, for example, the translation of a novel from English to Tagalog, or adaptation of a novel to film, and all that. So that's the second economic right. The third economic right is the exclusive right to first public distribution. So that means, an author or creator of a work can refuse, to distribute his work, can refuse not to publish his work. So this is an exclusive right of a copyright holder. However, this is subject to what we call the exhaustion doctrine, which means that the moment the author or the creator distributes in public his work, then this particular right is already exhausted. Right? So that means kung ikaw nakabili ng book niya legally, that book you can give to a friend, or you can do whatever you want with the book you bought. All right. The fourth one is the right of rental. The right of rental is not applicable to all authors or to all creators. It only authors or creators, because it only applies to particular works. For example, audiovisual or cinematographic works, a work embodied in a sound recording, a compilation of data and other materials, or a musical work in graphic form. So ito lang yung mga bagay, or ito lang yung mga works that have that give the author or the creator the right of rental. The next right is the exclusive right of public display. So public display is the showing of a copy of the work directly or by means of a film, slide, TV image, or other devices. So when we say public, we have to remember na, kasi this will also be used for the right of public performance. Public means a substantial number of persons outside of the normal circle of family. So medyo may requirement of substantial number of persons. How much or how many these persons are, there is no set rule. But of course, pag sinabing, let's say, but if it's not a private event, then necessarily it must be public. Okay. Now, the exclusive right of public performance. This is the sixth right. Okay. For public performance, there are different works, na pwede mong i-perform publicly. For those that are not audiovisual and not sound recording, you can perform a work by recitation, by playing, by dancing. Pag audiovisual naman, you can show the images in sequence and make the sounds accompanying it audible. So just show the audiovisual work. And at the same time, for sound recording, you make a public performance of the sound recording if you make the recorded sounds audible at a place or at places where persons outside the normal circle of family are present. So again, papasok dito yung idea ng public. And the last exclusive right of copyright holder is the right to other communication to the public of his work. So again, papasok dito yung making available to the public of his work. Pwede dito yung internet. So all of these rights, all of these economic rights are exclusive to the copyright holder. So if we have a clear idea of the exclusive rights of the copyright holder, then we can now move on to fair use. Because fair use, wait, before that pala, we have another right, the special economic right given to authors or creators of particular artworks like painting, sculpture, and manuscript. So dito, merong yung copyright holder has an inalienable right to participate in the gross proceeds of the sale or lease to the extent of 5% of their original work. So of the original painting, of the manuscript, original manuscript of a writing, or sculpture. Also, this, the moral rights. I'm sure you saw this during my first presentation, the moral rights of a copyright holder. Meron tayong the right of attribution and the right of integrity. The right of attribution simply means that the work must be attributed to the author, and the right of integrity simply means that hindi mo pwedeng baguhin or babuyin yung work ng isang author or creator. So, may klaro na tayong idea kung ano yung mga exclusive rights ng copyright holder. So, ibig sabihin, kapag may work, may copyright protected work, hindi mo siya pwedeng i-reproduce, okay, without the consent of the copyright holder. You cannot also perform it without the consent of the copyright holder. You cannot display it without the consent of the copyright holder. However, copyright protection is not absolute. And so we have copyright limitations. And one of those limitations is, of course, fair use. So yun ang pag-uusapan natin ngayon. And it will be very quick because I know you already listened to our director last time about fair use. But this is just a review. What is fair use? Okay. Medyo mahirap i-define ang fair use. According to the United States Copyright Office, of a rule of equitable, it's an equitable rule of reason that does not have a set definition. So each case, according to the USCO, each case raising the question of fair use must be decided on its own facts. In layman's terms, fair use as a limitation to the rights given to a copyright holder means that the user can exploit the work or can reproduce the copyrighted work without asking permission from the rights holder. Okay? Some also say that fair use is actually a copyright, a defense to an allegation of copyright infringement. So, kumbaga, just to illustrate, this is not a perfect analogy, okay? This is just to illustrate the point. Now, for example, someone attacks you with a knife, and then papalapit na siya sa'yo, and then you saw na merong ano dyan, tubo or whatever, and then yun ang kinampas mo sa kanya, and then nagkasugat siya, or namatay siya, or whatever, and then kinasugan ka sa court ngayon. You hurt me or you killed that person, and your defense will be self-defense, right? So in the same way, parang ganun yung copyright. Although it's not a perfect analogy, just to drive a point that sa copyright, eto si copyright holder, at ikaw na gumagamit, sasabihin niya, oh, you are using my work, you are reproducing my work, you are infringing on my copyright. And then here you are as a user, you can always say, hey, yes, I used it, but my use is fair use. So you cannot successfully sue me for copyright infringement. So I hope you got the point. It's not a perfect analogy, but hopefully you got the point that it's a defense. Now, under the Berne Convention, there are three tests that must that a user must overcome for him to be able to to say that the use or the reproduction of a copyright work is fair use. These are the three tests. One, the reproduction must be for certain special cases. Number two, it must not conflict with the normal exploitation of work. We will discuss this later. And three, the reproduction must not unreasonably prejudice the legitimate interests of the rights holder. Now, this three-step test is also, translated, or it's also adopted under the IP code through the introduction of the four criteria to be, or the fair use factors, the four factors to be considered whenever one uses or reproduces a work for it to be considered fair use. All right. The fair use factors are four. I also made there, parang mnemonics. Okay, Punas markets. For the so that it will be easier for you to remember the factors to be considered when using a work or reproducing a work. One, the purpose and character of the use. Number two, the nature of the copyrighted work. Number three, the substantiality of the portion used in relation to the copyrighted work as a whole. And number four, the effect of the use upon the potential market for or value of the copyrighted work. So let's go through them one by one. Purpose. As in the Berne Convention, under the first factor of the fair use doctrine in the IP code, the purpose must be for certain special cases. So, una, for example, you sa teaching, the purpose is for teaching, or it's for criticism, it's for comment, it's for research. All of these are legitimate purposes. Okay? So, kaya lang, hindi ibig sabihin na if it's for teaching, na kapag ginawa mo na siya, ginamit na siya for teaching, ibig sabihin fair use na siya. There are other factors to be considered. Okay? The other three must also be considered. By the way, why is fair use important? Especially for teachers. Kasi, like if you have students and they submit images, for example, sa project, or they submit essays na merong quotation, it's very impractical for the teachers to require the students na, oh, kumuha ka ba ng permission for that work? Can you show me the consent of the author for using his work? Okay, so it's very impractical. So, and that's why there is the fair use doctrine as a limitation to copyright. As Yusek Maria Bohok earlier mentioned, the limitations to copyright, particular fair use, is actually to enhance the creativity of the public and to give access to information and knowledge, especially to children, to the students. So there, teaching is a good purpose for the use or for the reproduction of a work to be considered. But this is not the only criteria. This is not the only factor. Okay. The second factor is to the nature of the copyrighted work to be reproduced. Okay. For the second factor, we have to identify the nature of the copyrighted work. So, for example, is it a poem? Is it an article from a periodical? Is it a song? Is it a music sheet? Because, bakit mahalaga malaman natin yung nature? This is connected, of course, to the third fair use factor, which is substantiality, which states that the significance of the amount reproduced, which means that which refers to the amount reproduced in relation to the copyrighted work. For example, quotation. So, ang nilagay ko dito is quotation, but what if it's a poem? It's a 250 word poem, and then sabi mo nag-quote ka lang, pero you quoted 200 words already. So is that fair use? Diba? So titingnan natin yung facts of the case. Pero most probably, if you quoted like 200 words from a 250 word poem, that may not pass as fair use. And so that's why, dun sa second fair use factor natin, meron tayong, tinitingnan natin yung nature of the copyrighted work. Right? And the fourth is the effect on the market of the reproduction of the work. For example, sa workbook, merong workbook na binebenta yung authors, and then ginamit siya, nag-reproduce yung isang teacher ng workbook para sa kanyang klase. And ginawa niya yon every school year. So di wala nang kinita si author kasi wala na siyang chance na mabenta pa yung kanyang mga of the work. Number three, the substantiality of the amount to be taken, to be reproduced from the work, and the effect on the market of the author must all be considered when we use the fair use doctrine. Under this particular example, meron tayong when the reproduced work substitutes for ayan, when then that definitely is not fair use. All right, now let's discuss this particular provision under section 185. Now I don't want to give specific examples because you may think that the examples I will give are the only instances of fair use, where you can use fair use doctrine, where you can invoke the fair use doctrine. So I just gave you the principles, the fair use, the four factors, and then this particular section from the IP code, which states that for classroom use, a teacher can make multiple copies for classroom use. One, the number of copies should not exceed one copy per student in a course. Okay, and it is also recommended that each copy should include a notice of copyright. Number two, the copying of the material is for only one course in the school in which the copies are made. And number three, there shall be no copying of or from works intended to be consumable. I think sinasabi natin kanina on workbooks in the course of study or of teaching. So again, if the teacher needs to reproduce a particular work for classroom use, multiple copies for classroom use, dapat one copy lang per student in a course, and that the copying is for only one course in the school. Okay, now here are the takeaways. Bago ko ibigay yung virtual floor to the next speakers. I have three takeaways. Three takeaways that I want you to have after this talk. One, the making of multiple copies of a work for classroom purposes should not be repeated with respect to the same work by the same teacher from school year to school year. Okay, so kasi kung yung paggamit ng multiple copies of work, so photocopy mo siya, multiple copies, year in and year out for your students, anong fair use factor ang affected? It's the fourth fair use factor, to be the right of reproduction. Diba? Number two takeaway. Dear teachers, be not afraid to use fair use. Okay? Lawyers will not always be there to guide you, but be not afraid to use fair use, because this is a legitimate right, or a legitimate, as you said, defense provided for in the IP code. And it is used to balance the interests of copyright holders and the public. And as teachers, you have every right, I would say, to access copyright works to benefit benefit the public, to benefit your students. So be not afraid to use fair use. But how do you use fair use? The third takeaway. Be reasonable. This is the only criterion. If you cannot remember the fair use factors, at least be reasonable, and that will justify more or less your use of a copyrighted work. Remember, there is no set rule, there is no standard. The fair use doctrine is not black and white. So do not be afraid to experiment. All right. And I have provided here like a guide to justifying fair use. Okay. I have like 5 questions there. One, what am I using? You have to identify again what you are using. Uh, this is pursuant to the fair use factor number 2. What am I using it for? Fair use factor number 1. Where did I obtain a copy of the copyrighted work? See, and then examine. Okay, examine. Is the use of the material will the material be used for the same purpose as the original purpose intended by the author? Because there might be transformation, okay, or derivation of the work from the original to the reproduction that you will make. And of course, explain why you made the selection. How much of the original will you use, and why are you using that much? So if you can answer all these questions whenever you use a copyrighted work, then most probably you can justify your use of it or your reproduction of the copyrighted work as fair use. So those, my dear teachers, are the takeaways that I want you to have in this very quick review of the fair use doctrine. Thank you very much for listening, and please listen to the next speakers. Thank you very much.
Thank you very much, Attorney Jeremy Bayaras. We will now proceed to our next presenter. Our second presenter is a graduate of the San Beda College Alabang School of Law. Previously, he has worked with the Department of Agrarian Reform as well as the Human Rights Victims Claims Board. At present, he is with the Accreditation and Standards Division of the Bureau of Copyright and Related Rights of the IPOCPHIL to speak about copyright exceptions and limitations relative to public domain, license, and open educational resources. We have Attorney Ezekiel Chuck Valerio. Sir, I think your audio is not active.
Sorry. Okay. Can you see my screen? I'm sharing my screen. Can everyone see my presentation?
Go ahead.
Not yet, sir.
Okay, for a while. Yan. Can everyone see my presentation? Okay. Can everyone hear me?
Yes.
Okay. So apologies again for the technical difficulties. Medyo nangangapa din tayo ngayon dito sa ating new normal na ito. But anyway, my presentation for this afternoon, it's continuation of my previous presentation on public domain and Creative Commons. Take note, hindi lahat ng OER ay under public domain. That might be a misconception that some of us might have. So these OER resources, they can be freely used and reused at no cost, diba? Libre yan. And without need to ask permission. So like the materials in public domain, there's no need to ask prior permission from the copyright owner bago gamitin ang mga OER resources na ito. Now, some resources, they can be downloaded and shared with colleagues and students, while others can be downloaded, edited, and reposted as a remixed work. So, anong ibig sabihin nito? Alisin natin yung assumption natin na lahat ng OER, pag na-download na natin, free resources are OER. Diba? So, take note of that difference. Diba? Some free resources, they may not be modified, they cannot be adapted, or they cannot be redistributed without express permission from the copyright holder. So, again, like tulad ng sinabi ko kanina, lahat ng OER free para gamitin holder. Pero hindi lahat ng free resources ay pwede mong gamitin kasi maaaring hindi siya OER. So, ibig sabihin, kung ganon, kailangan mo pa rin magpaalam sa copyright owner. Diba? So, merong ganong distinction. Let's be wary of that thin line between OER and those that are kailangan pa rin ng permission. So, if a lesson plan or activity is not clearly tagged as being in the public domain, then it is not OER. Titingnan natin, di ba? Kailangan specifically and clearly identified siya as being in the public domain or having an open license, di ba? Para siya ma-consider as OER. Otherwise, hindi siya OER. Okay, so let's remember that. Ngayon, short review lang. Balikan lang natin yung mga salient factors do sa previous lecture ko. Public domain, again, I'd like to remind everyone, these are not protected by copyright. Yung mga works that are in the public domain, they are not protected by copyright. Yun nga kasi, they are, yung protection nila, nag-lapse na, di ba? Or maaring hindi na-renew, gano'n, di ba? And then, they are usually, but not always free for all to use, di ba? So, like do sa previous lecture ko, di ba? There are certain instances like in the public domain photos, they are not free for all to use, di ba? Medyo may nominal licensing fee na babayaran. And then, of course, there's the dispensing with obtaining permission from the copyright owner, di ba? Yan ang pinaka relevant factor ng public domain work, di ba? So, hindi mo na kailangan magpaalam. And then, yun nga, review lang again, how the works enter the public domain. Pag nag-expire ng copyright niya, pag hindi na-renew yung copyright, pag dinedicate, di ba? Yung sinabi ko na talagang sinadya ng copyright or na creator na ilagay sa public domain. And then, yun nga, yung mga unprotected subject matter, di ba? Yung mga facts, ideas, di ba? Alam, na-discuss na natin yan. Again, a short review. Ano ba yung Creative Commons ulit? Di ba? It is a non-profit org devoted to expanding the range of creative works available. So, sila ang nag-release, di ba? They came up with the Creative Commons licenses system, di ba? So, ito ang pinapagamit nila sa mga creators na gustong luwagan yung kanilang economic rights para mas magamit ng iba yung mga works nila, di ba? Again, a short review of the different Creative Commons licenses kasi importante ito with regard to OER, di ba? Yung CC-BY attribution, di ba? Pwede ka mag-distribute, remix, tweak, and build upon the work, di ba? And pwede rito yung commercial use, di ba? Again, ang hindi mawawala dito, whatever type of license, kailangan merong credit do sa original creation, do sa original author. Laging merong right of attribution, di ba? Now, this is the most accommodating of licenses offered, and it is recommended for maximum dissemination and use of licensed materials. So, kung ikaw ay creator or kung may balak kang gumawa ng material na gusto mo siya maging OER, having it licensed under a CC-BY attribution is kumbaga yun yung pinakamainam na paraan para ma-disseminate yung iyong material, diba? At maraming makagamit ito. Next, yung CC-BY-SA, diba? Pwede ring mag-remix, mag-tweak, mag-build upon the work. Again, commercial purposes. Again, merong right of attribution. And then merong pwedeng i-license yung new creations under identical terms, diba? So yun yung SA, share alike, yung ibig sabihin. Now, this is particularly important if your work also includes other people's materials licensed through the Creative Commons. So, to differentiate it from the first license, kung ikaw ang gagawa ng OER material, kung lahat ng material do sa OER mo ay original, meaning ikaw talaga lahat gumawa nun, sa'yo lahat ng galing yon, CCBY ang okay na license doon, di ba? Yun yung combination and use. However, kung meron kang ginamit na material ng ibang tao, na itong material na to ay licensed through Creative Commons system also, then instead of using the CCBY, the first one, CCBY SA ka. Diba? Yun yung mas maganda mong gamitin kasi dahil siya doon sa share alike na ano niya, na function license new creations under identical terms. So mas pinapalawak mo rin ang under identical terms. Next, the CCBY-ND. It allows for redistribution, both commercial and non-commercial, as long as it is passed along unchanged, di ba? So wala kang binago, walang build upon, di ba? And then of course yung credit, hindi naman nawawala yan sa kahit anong license. CCBY-NC, ano naman to? So dito, again, pwede na mag-remix, mag-tweak, mag-build upon. However, non-commercial, kaya nga NC, diba? So non-commercial purposes only. Okay? And although the new works must also acknowledge U and B non-commercial, so meaning meron pa rin right of attribution yung author, hindi na kailangan i-license yung derivative works on the same terms. So walang share alike. Diba? Walang SA na function. As distinguished from the next one, which is CCBY and CSA, so pareho lang, but dito, kailangan i-license yung new creations under identical terms, hence the SA designation. So yun lang ang difference yung dalawang yun. Now, the last one, CCBY, NC, and D, ito yung most restrictive of the 6 main licenses. Ang pinapayagan lang dito ay i-download ng iba yung work mo at i-share with others as long as mayroong right of attribution. Pero they cannot change the work in any way or they cannot use them commercially. So this is one thing siguro to consider if you are a creator of OER materials, 'di ba? Baka hindi ideal itong type of license na to if your main goal is the wide dissemination of your work. At the same time, kung ikaw naman ang user ng OER at meron kang gagamitin covered by this type of license, then you have to be aware na ang pwede mo lang gawin is yun nga, i-download yung work and then share with others as long as may attribution, pero walang tweaking, walang remix, walang building upon, at walang commercial purposes. So let's take note of that. So ayan, pinapakita ko lang sa inyo ngayon yung different logos para sa different types of licenses. So yan yung pag nakita nyo, usually pag naka-download kayo ng OER material or any type of Creative Commons licensed work for that matter, merong ganyang nakalakip na parang legend do sa either sa download link or whatever. So this is your guide kung anong klaseng license yung naka-attach. Again, tulad na sinabi ko before, if a user violates the terms of the Creative Commons license, then it is tantamount to committing infringement. Because remember, Creative Commons license works, they still have copyright protection. It's just that the copyright owner, dahil sa gusto niyang mapa-disseminate yung kanyang work, he is waiving certain rights that he is usually entitled to, lalo na pagdating yung mga economic rights niya. So, win-waive lang niya yung iilan, but hindi lahat. So, meron pa rin copyright. Let's not forget that. So, we now go to the 5 core principles of OER. First, reuse. This is the most basic level of openness. People are allowed to use all or part of the work for their own purposes. For example, nag-download ka ng educational video for offline use, diba? So, nag-download ka para mamaya pwede mo na siyang panoorin at any time of your choosing. So, that is an example of reuse principle. Next, the redistribute principle, meaning people can share the work with others. So, for example, meron kang nakuwang digital article online, pwede mo siyang isend to a colleague by email, di ba? Or nowadays, siguro, pwede yung isend mo siya via an attachment sa Messenger, halimbawa, ganon, or kung ano mang messaging app ang ginagamit, di ba? So ito, redistribute. Next, revise, meaning that you can adapt, modify, translate, or change the work. So for example, merong libro written in English, translate mo siya into Spanish or any other language. So that is a form of revision, diba? Meaning na yung original work minodify mo or binago mo, diba, into a new work. So that is a revision. Next, remix, meaning that people can take two or more existing resources and combine them to create a new resource. So, example, yung pag meron kang kukunin na audio lecture from one course, tapos meron kang kukunin na slides from another, and then gagawa ka ng bagong derivative work. Or, di ba, best example ng remix, yun nga, yung remix, music yan di ba? Yung sampling, meron kang kinuha na beat from one song, meron kang kinuha na guitar riff from another song, meron kang kinuha na whatever type of melody from another song, combine mo into a new derivative work, diba? That's yun yung tinatawag natin na remix, diba? It's the term itself, diba? Parang na-associate natin siya with music, diba? So yun yung best example. Now, the last core principle is retain, meaning walang DRM, no digital rights management restrictions. Itong DRM na to, ito usually yung nilalagay as protection para hindi magamit openly ang isang digital content. So parang naka-embed siya So if a work is OER, walang naka-embed na DRM restrictions, 'di ba? Kasi obviously kung meron, hindi mo siya terms meron pa ng mga restrictions na hindi mo nasunod. So maaari ka maging liable for infringement, 'di ba? Also remember, when searching for possible OER resources on the web, check always to see whether or not it has a CC license or a statement giving permission for reuse. Kasi it may be common practice to use free resources without worrying unduly about copyright, but there are risks without a clear license or permission for reuse. So again, it's just an elaboration of the first of our first tip na kailangan always check the terms, diba? Always read the fine print. And ang example dyan, there are certain sites such as OpenLearn, they only allow individual personal use for non-commercial purposes. Okay? Which means providing a link to the site for students rather than integrating the materials directly into your own teaching. So we have to be aware, meron certain online resources ng mga OER na merong ganitong restriction. Okay? Na ibig sabihin, hindi mo pwedeng kunin yung materials that are available on that website at i-integrate mo siya directly sa pagtuturo mo. Ang pwede mo lang gawin ay to provide a link to the site para yung students, pag gagamitin na nila, they will use the link to go to the site rather than acquiring the resources directly from the site and then giving them to the students. Yeah, so we have to be aware may mga sites na may ganon. Okay? So if there's any doubt about the right to reuse, check with your library or intellectual property department. That's kumbaga, just to be on the safe side, diba? When in doubt, check with your library or check with the IP property department. Okay, so here are just a few helpful links na maaaring makatulong sa atin when it comes to OER. Nandiyan yung sa UNESCO. Itong UNESCO site link na to, marami ditong mga downloadable na publications tulad ng Basic Guide to OER at guidelines for OER in higher education. Next, yung itong open textbook. This is a link which contains text license to be freely used, adapted, and distributed. Next, itong aggregator nito, 16 OER sites every educator should know, and other similar site aggregators. So marami dyan, siguro just Google na parang best OER resources, mga ganun, di ba? Just use the similar keywords to that. And then, andito yung open for us that it is a guide to finding and using OER. Okay? So with that, thank you very much. I hope na medyo naliwanagan kayo with regard to using OER, lalo na ngayon in this distance learning environment. So again, let us not forget yung OER, di ba? Wag natin i-assume na public domain lahat ng OER materials. Always read the fine print. Always check the terms and conditions of the licenses kung meron mang naka-attach. And yun nga, when in doubt, always check with your library or IP department. Or when in doubt, again, general rule when it comes to copyright, when in doubt, better to ask permission. So with that, again, I'm Attorney Chuck Valerio from the DCRR. Thank you very much, and we'll now go to our next speaker.
Thank you very much, Attorney Chuck. And as he said it, we will now proceed to our third speaker. Our third presenter is the Director 4 of the Bureau of Copyright and Other Related Rights of the Intellectual Property Office of the Philippines. His office handles policy issues on copyright and related rights, accreditation of collective management organizations, and adjudication of cases on copyright, among others. He holds a Bachelor of Laws degree from the University of Perpetual Help System Laguna and a Master of Business Administration degree from the University of the Philippines. He finished his undergraduate degree, Bachelor of Arts degree in Social Sciences, with a double major in Economics and Political Science from the same university. Presenting on copyright limitations and exceptions on broadcasting, he is Attorney Emerson G. Cuyo. While we wait for Attorney Cuyo to reconnect, again, we would like to reiterate some reminders which you should also take note of for Monday's session. That the presentations will be made available to you through the emails you provided. So make sure that they are active and legitimate emails. Again, we would love to hear from you, especially after listening to the two presentations. Should you have questions, please feel free to send them through the questions tab visible at the left side of the screen and to your right. In the interest of time, the questions are already being filtered to that within the coverage of the webinar topic only. We will have our speakers answer your questions after the presentation of Director Cuyo. I believe he is already on screen. Again, to present on exceptions and limitations on broadcasting, here is Attorney Emerson G. Cuyo.
Okay, can you hear me? Thank you very much. Am I coming in clear?
Yes, sir.
Okay, thank you. So thank you to the previous speakers, to Attorney J and to Attorney Chuck. As explained by Attorney J, dapat nauna po talaga yung portion on public domain, OER, and Creative Commons, because that's the easiest way by which you can source learning materials without really being violative, without running the danger of being violating the copyright of another person. May mga idadagdag lang akong konti. So the question is, how do you know when looking or sourcing for materials that the material is one covered by Creative Commons. Again, as mentioned by Attorney Chuck, it's actually there. Kung online siya, kung born digital yung material, you would usually have a portion there sa link or sa mismong material. Like for example, meron siyang thumbnail. You would usually see notice, parang yung sa mga libro. Di ba sa libro meron tayong tinatawag na copyright page or copyright notice. So makikita nyo din po yan. If it's a physical book, you would note that usually after the title page, sa likod nun would be the copyright page. And you would see exactly yung itsura na pinakita ni Attorney Chuck kanina, yung merong graphics about CCBY, NCNB. So that's how you know that the material is covered by a Creative Commons license. What about kung yung material na nagawa nyo, and that is a decision, I guess, of the institution, of the department as a whole, how about if the materials that you already made, you wanted to cover it with a CC license? How do you actually do that? The way to do that is you just choose from among the options of the CC license, as mentioned and explained by Attorney Chuck. Then you link it and you register it with the Creative Commons page so that they have a record of the Creative Commons license on your particular work. And finally, as mentioned also, but I would like to reiterate that Creative Commons license does not mean that it is part of public domain. Hindi po pareho ang public domain at saka ang Creative Commons. Ang Creative Commons means that it is still covered by a license. There is still a copyright subsisting, except that the author or the creator of the work wanted to be more liberal in letting others share or use his work. And correctly, if there is a violation in the license, remember may terms and conditions pa rin yan. So like for example, CCBY, so you have to acknowledge the creator and you did not, then it may be a ground for pursuing a case of copyright infringement. So yes, copyright pa rin, under copyright pa rin yung Creative Commons. Maybe the only one that will lean to the copyleft movement would be yung CC0, when there is a public dedication of the work. So wala totally restriction. I think that one would more or less lean towards the copyleft movement. Then doon sa because I have a few slides lang naman, doon sa discussion ni Attorney Jay, unique ang Philippines in terms of fair use because we actually put the 4 factors test, yung 4 factors, we actually put it in the law under 185. If you look at other laws, hindi sila ganun ka-specific. In fact, yung 4 factors na yan is a product of US jurisprudence, from which we got also certain portions or most, if not many of the provisions of our copyright law. So, yung kumbaga naging part lang ng decision sa US, we actually adopted it. And I think that is good in order to promote, again, yung social function portion ng intellectual property, aspect ng intellectual property, so that more of the public can use and can build on and can have access to the work. But more than that, there is actually 184.1, which I discussed na in the previous discussion. 184.1, it's an entire enumeration from letter A to letter L. So HIJKL. So that's 12 in the enumerations na nagsasabi na itong mga instances na to, mga situations na ito, when you follow them and when you meet the conditions stated there, would qualify as fair use. So meron tayong madami. There are actually a lot of options on uh, fair use, no? Yung law na yung mother treaty on copyright, which is the Berne Convention, actually isa lang po ang exception doon, ang mandatory na exception na kailangan i-adapt ng bawat bansa. And that mandatory exception is the mandatory exception of making quotations. So, meron din po yan sa ating batas. It's in, I think it's in letter A, 184.1A. But the Berne Convention actually allows countries to provide other situations that will be considered as fair use. And that's why dun sa Berne Convention, in-adopt yung three-step test. Yung three-step test na yan, dapat yung exceptions would only be in special cases. It will not unduly prejudice the interest and the market of the copyright holder. Okay, and does not interfere with the normal exploitation of the work. So, madami po yan na available. So, on that basis, I will now proceed to this discussion of mine. Actually, hindi ko po alam, hindi ko pa po fully na-appreciate the interest of DepEd in this particular discussion. I just know from the discussion with Director Rowan that part of the way you will deliver the teaching and the learning is through broadcasting. That's why I think there was there was a request to also cover broadcasting as part of limitations and exceptions. So siguro let's start by understanding what broadcasting is. So I started with the definition of what broadcasting is. If you are wondering, this is in the law. Okay, so hindi po ito galing sa Google or anything else. It's in fact part of the copyright law. And broadcasting is defined as the transmission by wireless means. So I underlined there wireless to emphasize that broadcast does not include transmission by wire. Okay? So broadcast, to qualify it, and later on makikita nyo na may mention in the exceptions or statutory fair use about broadcast. So broadcast, again, does not include transmission by wire. So it only means transmission by wireless means for the public reception of sounds or of images or of representatives thereof. Or pwedeng combination, sounds, and images. So that's okay. Basta ang transmission is by wireless means. And recently, in-include din yung transmission by satellite is also considered daw as broadcasting where the means for decrypting are provided to the public by the broadcasting organization or with its consent. Anong example nito? Ang example nito would be when there is a password or you have to use a certain device in order to actually be able to receive, as the user, to receive the broadcast or to receive the sound, image, or sound and image. So again, broadcasting is wireless or satellite, does not include transmission by wire, such as in your cable operations. So broadcasting organization, on the other hand, shall include a natural person or a juridical entity like a corporation or an institution or a group entity duly authorized to engage in broadcasting. So having defined, and I hope that's already clear with us, having defined already what broadcasting is, we are now ready to proceed to the next slide, which is communication to the public. Remember when you went through a quick review of the rights of a copyright holder, one of the rights of the copyright holder is actually communication or other communication to the public. So ano ba ang definition ng communication to the public? So communication, this is also in the law, except na pag tinignan mo kasi yung law natin, there's a definition under the portion on copyright proper, and there are definition of terms also under the related rights portion. So this one is a mixture of both because they will actually refer to both copyright works and related rights. Okay. So communication to the public means any communication to the public. Define nyo na rin kung ano yung public. Any audience that is, when it's supposed to be before an audience outside the normal confines of a family. So in other words, the only distinction, wag nyo na pong alamin kung public ba yan o hindi, kagano ba kadami. The short portion, the other side, the kabaliktaran ng public is private. So if it's not a family affair, then it's not considered as public. Then it's considered as public if it's not a family affair, including broadcasting, rebroadcasting, retransmitting by cable, broadcasting and retransmitting by satellite, and includes the making of a work available to the public by wire or wireless means in such a way that members of the public may access these works from a place and a time individually chosen by them. I would like to emphasize na dito sa definition, so in other words, communication to the public is a broader concept. It does not include only broadcasting, but it actually includes transmission by wire, and unique din ito sa atin because in other jurisdictions, meron silang tinatawag na making available right. Ano yung making available right? Members in such a way that members of the public may access these works from a place and a time individually chosen by them is what you call as the making available right. So in other words, sa ating copyright law, communication to the public includes both broadcasting, transmission by cable, and the making available right. So broadcasting is an exclusive right of the copyright holder included in the term other communication to the public. So therefore, when you make something available in a storage for others to view or a member of a bigger group to view, which is making available, hindi po yon public performance ang tawag. Ang tawag po doon, and it falls within the exclusive right we call as communication to the public. Let's now go to the specific provisions where the term broadcast or broadcasting is mentioned. So the first one is in section 184.1. Sabi ko nga, may mga specific statutory fair uses under 184.1 from A to L or M, L. So 184.1E mentions that the inclusion of a work in a publication, broadcast, or other communication to the public, or its inclusion in a sound recording or film, if such inclusion is made by way of illustration for teaching purposes, and is compatible with fair use, provided there's a proviso there. Ang condition daw niya that the source of the and of the name of the author, if appearing in the work, are named. So dapat there is you should cite the source and the name of the author if appearing in the work. Kung wala naman, then of course there is no way by which you can comply with this proviso. So nakita nyo po na underline yung word na work. And work under the copyright law refers to anything. Basta work, creation, intellectual creation, or creative expression. So it can be an essay, a poem, an article, a song, a musical composition, a photo, can be included in a publication, in a broadcast, or other communication to the public, or can be included in a recording or a film, for as long as it is by way of illustration for teaching purposes and is compatible with fair use. So babalik kayo doon, when you talk about fair use, babalik po kayo doon sa four-factor test. Okay, four factors in fair use. Okay, so the authors, so ano ang conclusion natin dito and ano ang what can we get out of this particular provision? The author's right to forbid the inclusion of his work in school broadcasts and sound and visual recordings made for teaching ends has been cut down or has been limited by this provision. Expressly yan, that it is a limitation to the exclusive right of the author of a work to forbid o pagbawalan ang iba na gamitin sa school broadcast or in a sound and visual recording pag ang pag-include dito is for teaching ends. So it's a limitation. This exclusive right has been cut down or limited by this provision. Assuming, of course, that this same is compatible with fair use, specifically, it does not conflict with the normal exploitation of the work and unduly prejudices the rights holders' legitimate interest. Sabi ko nga medyo unique because we adopted the four factors test. So, yung iba sa atin and even among lawyers, nako-confuse between the four factors and the three-step test. The three-step test is what is provided under the Berne Convention. And under the Berne Convention, sinasabi niya na pag ang legislator, ang wording kasi ng Berne Convention, it is up for the legislation of a particular member of the union whether magpo-provide siya ng other exceptions to copyright. So in other words, yung three-step test was actually designed to guide our lawmakers and legislators para sa paggawa nila ng exceptions and limitations, or in this case what we called as statutory fair uses. And the other one, so again, ang conclusion dyan, express po yan, should be by way of illustration. So if you are going to illustrate, it does not mean also that you, because may fair use dapat eh. So if you are going to illustrate only something, a concept, a principle, or you want to drive home a point to your particular class or to your students, then definitely there is no necessity to cite the entire thing or to copy the entire thing or to include everything, a particular, lahat ng buong work, 100% of the work should be included. Why? Because again, the purpose is only for illustration and teaching purposes. The other statutory fair use provision where there is a mention of broadcasting is in section 184.1F. The recording made in schools, universities, or educational institutions of a work included in a broadcast for the use of such schools, universities, or educational institutions is considered as fair use. Actually, ang wording ng batas is does not constitute infringement of copyright. It makes that particular and decisive statement na lahat daw ito, 184.1, A, B, C, D hanggang L, does not constitute copyright infringement. So, yung broadcast recording, but the operative word here and the act here being referred to is the recording. It's not actually the broadcast. There is a broadcast, but the act being referred to is actually recording. So pag ni-record mo, such as your students, or maybe a teacher, or maybe another personnel of the school, okay, records a broadcast, okay, that was intended for the use of such schools, universities, or educational institutions, okay lang din daw yung. So let's, for example, I don't know the specific provisions. So for example, there's an online broadcast program or TV program that is intended through an agreement with DepEd, is intended for use by public schools. So may broadcast ngayon siya, and then ni-record ng school official or ng teacher or even ng students. Yung broadcast na yon, is that now considered as copyright infringement? Remember, the broadcast organizations also have their rights, and I will mention that later. So, is that okay? Under this provision, okay lang daw yung recording na yon, pero kailangan mong i-meet tong conditions na to. What are the conditions? Those are the provisos. So, provided that such recording must be deleted within a reasonable period after they were first broadcast. So, dapat, ni-record mo siya, so, pero, dahil it's an allowed recording, parang it balances kasi. You don't need to ask permission of the broadcast organization, but you have to delete it within a reasonable period of time. Yung reasonable period of time is not set in the law. However, if we follow 1976 Tunis Model Law on Copyright, which was commissioned by the WIPO, it actually provides there that it should be within a week. But yun yung parang standard na trinay-introduce dun sa model law. But dito, it's not there, but we will put it in a provision of an implementing rules and regulations. So we enjoin you to, when that law is, when that IRR is going to be presented for consultation, we enjoin DepEd to comment also on the particular or specific implementing rule and regulation. So, must be deleted within a reasonable period, and provided that hindi ang recording should not be of an entire audiovisual work or what you call as your movies or films. Because obviously, if you copy or record an entire audiovisual work, which is yung halimbawa, bagong palabas na sine, if you copy that, there can be no excuse, no defense for such use, even under this particular provision. Why? Sabi dito that such recording may not be made from audiovisual works. Ano ang pwedeng gawin ng schools, ng students, or ng teachers? They can actually, again, make excerpts for brief excerpts. Of course, but I think the purpose there is just to drive home the point that it should be a small portion of the work. Kasi excerpts are supposed to be brief, but the law says brief excerpts of the work. So I think just to emphasize and drive home the point that this should not be a substantive portion of the work. And again, pwede nyo siyang i-relate doon sa making use of a work or the inclusion of a work in a broadcast. So this one, hand in hand goes together. So kung yan as users, itong exceptions na to are provided as a defense. In fact, sabi niya, will not constitute copyright infringement. So ito is for the benefit of the users of a work. Okay. However, we have to remember kung ito naman ang interest ng DepEd because it will produce its own materials or content, then I think you would find the applicable provisions as regards your broadcast in another section of the law on related rights. Ang broadcasting organization po kasi, ang tawag sa kanya sa mga karapatan nila ay hindi na broadcast, ay hindi copyright kundi related rights. So what are the rights of a broadcasting organization? The rebroadcasting of their broadcast. Uulitin, yung broadcasting. The recording in any manner, including the making of films or the use of videotape of their broadcast for the purpose of communication to the public, of television broadcast of the same, and the use of such records for fresh transmission or fresh recording. However, I think, and this is an ongoing negotiation sa World Intellectual Property Organization, yung Broadcasters Treaty. Because of the three related rights, I know there are lawyers in the group, of the three related rights, which is the rights of performers, the rights of sound recording producers or your record labels, and the right of broadcasting organizations, eto na lang yung walang treaty existing at the moment covering the right of broadcasting organizations. Why am I saying this? Because under present circumstances, DepEd might not qualify as a broadcasting organization, or even if it qualifies under exceptional terms as a broadcasting organization, pag ang means niya is purely via internet, okay, then dinefine natin kanina yung broadcasting, that will not qualify. Because yung purely internet ang operations is under the contemplation now, yung pinag-uusapan sa international treaty, is not considered as a broadcast organization. Ano example niyan? Halimbawa, ang model nyo or style nyo is parang Netflix, where you have access, that's the time you can access the materials, but that's purely internet business. Nothing about broadcast. So, yun, hindi siya mag-a-apply because then you will not qualify as a broadcasting organization. But nevertheless, I stated this for your purpose and to drive home the point na you have other exceptions under fair use that you can actually avail of, in particular your section 184.1 E and F. So I think that's about it. Very short, again, because broadcasting is not really very defined at the moment. So on that basis, I think we will be ready to break and to answer some of your questions. Thank you.
Maraming salamat po, Director Cuyo. Again, this is very timely, no, as we prepare to venture into distance learning. And broadcasting, again, is one of our platforms for the continuation of education for the incoming school.
I-clarify ko lang po, yung broadcast is not just TV, it actually includes radio.
Noted po, Director. At this point po, we would like to invite back on screen our resource speakers for a short open forum. I will now turn you over to Attorney Arturo Shoson Jr., OIC Chief of the Legal Division, Legal Service, who will moderate the question and answer segment of today's session.
Good afternoon, Attorney.
Good afternoon, everyone. Good afternoon. Thank you po again, Director Emerson, Attorney Chuck, and Attorney Jeremy. Thank you very much for your presentations. And as what happened po in the previous webinar, we have a lot of questions coming in from our participants, and I believe even Attorney Chuck has tried to answer some of them.
Okay.
I've seen some of the questions that were answered. Although again, unfortunately, again, as there's so many questions, I think there's like more than 700 of them flooding in. So it would be really difficult to answer all of these questions. So we'll try our best to select the common questions that keep on repeating themselves. Siguro po to start off our Q&A part of the webinar, we can anyone can answer po siguro between our among our presenters, siguro while if Director Cuyo is still taking a breather from his presentation, anybody po can answer for him. One question that we have po is that with regards to copyright and work of government, we would like to any of our presenters to elaborate on work of government and copyright. Since as you may know, we are in DepEd, so some of our teachers are the ones who are developing our learning materials, our learning resources, and at the same time they are employees of the government. So can you please elaborate on how the term work of government and copyright are related to each other?
Yes. I'll start answering, and perhaps Attorney Chuck and Attorney Jay can add on to it. Yung provision in the law that there is no copyright did not refer to the government. It referred to government works. And therefore, ang walang copyright protection are the works of the government. But the government can actually be the owner of a copyright via assignment, bequest, or otherwise. That's what is stated in the law, from another person. So it can actually be from a consultant, because a consultant is under the law not considered as and in upcoming implementing rules and regulations on works of the government, hindi siya organic kasi sa government ang consultants. So pwedeng yung work ng isang consultant of the government, siya ang may-ari because there is of course copyright because he's the creator, and can assign the work to government. So in that sense, in that particular example, si DepEd or any other agency of the government can actually be the holder of copyright. Ang wala lang pong protection are those which are considered as government works. Ano yung government works? Ito yung mga ginawa ng mga employees of the government which is part of their regularly assigned duties. Sabi natin doon sa lecture last week, there's actually a portion on copyright ownership. And sabi natin, under an employer-employee relationship, the owner of a work, if it forms part of his regular duties, automatic si employer ang ano doon. So in that sense, then the works by your regular employees will now be considered as works of the government or government works, and therefore following the provision of the law does not enjoy copyright protection. Pero the same section also provides, so in other words, because it does not enjoy copyright protection, it's actually part of public domain. In essence, it's actually public domain. But merong provision doon na and therefore, dahil part of the public domain, you can have free use of it. Pero nandun kasi sa law na pag ginamit mo yon for purposes of commercial purposes or for profit, halimbawa, DepEd modules, although walang copyright, somebody reproduced it and binenta niya, nagpatong pa, hindi lang at cost, kundi nagpatong pa yung teacher or whoever or maybe a third person, then that is considered as using the government work, which does not have copyright, okay, for profit purposes. And therefore, whoever is the concerned agency can take actions on it. Chuck or Attorney J, you want to add anything?
Yes, so again, to emphasize lang, so kung in your example given, kung teachers that are employed by DepEd, so malinaw na government employees sila, di ba? So, any learning materials that they develop in the course of their regular performance of their duties, these are considered as government works, di ba? Okay, hence, they are not protected under our copyright law. They are unprotected subject matter. And then again, yung sinabi ni Director Cuyo na hindi po porket ang isang government work ay walang kasibihin nito na kahit sino na lang ay pwedeng gumamit ito, di ba? General rule pa rin is kahit walang copyright yung government work, kailangan pa rin magpaalam dun sa agency concerned bago gamitin yung work na ito, even if walang copyright protection ito.
Thank you po. Thank you, Attorney Chuck. Thank you, Director Cuyo. And another, it's actually a very common question.
Attorney
sige po.
Shoson, can I add? Because I was in a discussion, may nakita lang akong post kagabi sa Facebook, which says na bakit kaya si modules daw, I think there's a notice the copyright protected siya and naniningil daw ng sa akin o to royalty. Although I explained that while there is no copyright in government works, whenever the works is again used for commercial purposes, the government, as the producer of that work, okay, the agency, can actually collect and make certain conditions, including the collection of remuneration akin to royalty. Hindi royalty ang tawag because there is no copyright in it, but they can impose actually and collect fees that is almost similar or akin to royalties.
Thank you, Director Kuya, for further explaining, that. And another question po that we have is with regards to lifting pictures from the internet. It's actually po a very common question. It's about lifting lifting pictures, videos, content basically from the internet. The question is, would it be okay to get pictures off the internet without citing the source? for example, if it's indicated as free on Google, if you search on Google and it says it's diba there's you can sometimes search for free images. Google several images pops up. Is this advisable for them to use it without citing any source?
Uh, I'll get this question. Again, siguro best course of action dito at to be safe lang, let us not always assume na lahat ng makita natin online, they are free, di ba? Even if you Google, for example, ang keywords mo ay free images and then merong lumabas, let us not assume na lahat ng lumabas na yan ay talagang free. We have to do our due diligence and check into the terms and conditions kung meron namang naka-attach sa particular image na yon, dahil maaring namang wala, maaring public din rin siya, so in which case walang problema. But more often than not, most of the images online, they have some kind of copyright protection attached, either full copyright or Creative Commons licenses. So we have to abide by the particular terms and conditions attached to each image. Let us be careful lang, wag parang bara-bara lang na kung ano lang makakita online, grab and then ilagay sa work natin, di ba? We have to be careful because most of these content that we find online, again, they are copyright.
Yeah, I agree with Attorney Chuck. In fact, if you click on certain pictures, pag clinic mo siya, actually meron siyang notice minsan na nagpa-pop up that you should cite this, use this particular series of words to make the citation. So, tama yung recommendation that just be careful. I think the problem lang with when you do that is it becomes a bit of a tedious process, especially when you are using and you are including a lot of materials such as photos from Google or from the internet. I think yung pagka-tedious niya, especially if you're going to reuse the materials, I think it pays to go through that rather than being later on liable or somebody coming after DepEd or whoever is the person involved or department involved claiming about copyright infringement. I think about in June of this year, 2020, there was actually a big case in the US about mga online learning resources. And in fact, the group, the big group of rights holders in the U.S. are now suing a particular school. It just escapes me now kung anong particular school that did that recently in June.
Thank you po, Director Cuyo. Thank you for further explaining that. Related to that po is also, I believe, yung sa YouTube is it safe to get videos from YouTube? Parang what you explained, yung you have to be tedious in searching for if it's available for use. Ganun din po ba with videos online like in YouTube? Kasi I believe po merong may lumabas na issue po ang YouTube that they have a disclaimer for all the videos that are posted on their site. Are you aware po of this?
I'm not aware of that particular disclaimer, pero yes, insofar as YouTube videos are concerned, again, karamihan dito, they are covered by copyright. In fact, di ba, pag nag-play ka ng isang video, sa baba nun, di ba, parang I think drop-down link or something na pag kinilik mo, lalabas yung copyright information ng video, di ba? Problema lang kasi most people na they just browse through YouTube, they fail to click on the link, so hindi nila nakikita yung relevant copyright information, di ba? Pero andun na kasi yun, doon makikita kung sino yung, kung kanino nakaka-copyright. For example, yung song na pinapatugtog doon sa video, doon makikita kung ano, yung terms ng license kung meron man. And then, kung click mo, at least doon, walang problema, di ba? So, ano lang, same advice that I gave kanina in doing due diligence sa pag-check ng photos, it applies to adapting videos from YouTube.
Thank you, Attorney Chuck. Can you give po any specific guidelines for our teachers who are doing this right now? They're searching for images, pictures, content online. Are there like steps that they can take to ensure that yung magamit nga nilang content, pictures, videos, are give us specific na steps, guidelines?
Jay?
Siguro ano lang, specific steps, kasi ano it would actually depend kung sa klase ng content na hinahanap nila. Pero usually, if it's copyrighted, meron copyright notice yan na naka-attach. You just have to look kung saan man siya makikita, kasi yung iba parang merong maliit lang na parang disclaimer or notice sa ilalim, yung iba nakatago sa link, yung iba, in other words, hindi madalas na na obvious agad yung copy material yung tinitingnan mo, di ba? So I don't think there are really exact steps that we can prescribe, pero yun nga, just always do your due diligence, at talagang lang, general rule again, when in doubt, better to ask permission, di ba? It's better than assuming na makakatakas ka under fair use or kung under it's a better assumption to ask permission pag medyo may konting duda ka.
Thank you, Attorney Chuck. Sa ano naman, with regards to music, which is also a concern for some of our teachers, if they, for example, if they play background music sa mga school activities, school, for example, sa private schools, they have school fairs. If they play copyrighted music, is this allowed under fair use? Hello?
Sorry, let me just refer lang to the provisions on the fair use portion. Unless the other two lawyers can help out.
Sige po.
The first, is my audio connected?
Yes, Attorney Ray.
Okay.
Yes, we can hear you, Attorney Jeremy.
The first of the enumerations under Section 184 states that recitation or performance of a work, once it has been lawfully made accessible to the public, if done privately and free of charge, or if made strictly for charitable or religious institution or society. So, if the song, for example, that is in the question, if the song was already recited or performed in public, or the right of distribution was already exhausted by the copyright holder, then the performance of that work for private purposes and free of charge can be made lawfully by the school, and it will not be considered an act of infringement.
Or I may refer you aside from that, and I think baka mas this one is even closer. 184.1I, the public performance or the communication to the public of a work in a place where no admission fee is charged in respect of such public performance or communication by a club or institution for charitable or educational purposes only, whose aim is not profit-making and subject to such other limitations as may be provided in the regulations. So right now, we don't have the regulations for this. So I think it's safe, whose aim is not profit-making. So, like for example, a club or a school organization sponsors something, and in the process or may program, ginanap siya sa auditorium where there is no admission fee. And I think you have to be very careful about that there is no admission fee, because that's a specific qualification or requirement under the law. Then I think it would come under that particular fair use. So yes, there are available provisions under 184.1 that you can avail of.
Thank you po. Thank you po, Director Emerson and Attorney Jeremy. Thank you. Thank you for that answer. Almost parang lahat na po ng I think it covers all of the use of music halos ng mga teachers natin. Whether they use it in the classroom, in
Yes.
presentations. I believe your answer covers it all. And how about sir? How about if yung ganitong for a webinar like this, if you use copyrighted music, pasok pa rin po ba sa limitations? Like in a webinar like this, a presentation like this?
Well, I'll share to you what we do at IPOPhil, being the intellectual property office in charge of implementing state policies. Kami then, we follow the rules stated by Attorney Chuck. When in doubt, we do not play. So if you notice, if you've listened into one of our consultations, we usually do not play music, especially when we are uncertain about its background. Kanina before the webinar went live, yun, pwede nyong gawin yun. And I think that's the easiest way to do it eh. Unfortunately sa Philippines, wala pa tayong ganong registry of works in the public domain. But that's the easiest way to go about it. Find a registry of musical works that are already in the public domain, and you can use it in any manner or way. Kanina kasi narinig ko yung Ilocano because I'm Ilocano, o Naranyag Abulan. That one is obviously in the public domain, and therefore it's okay to use that as a background music. Unless it's a particular recording na subject to copyright. I will have to clarify that. Kung plinaka siya, there's a group of singers that covered that particular song, although yung song itself is already in the public domain, yung recording is subject to a separate right called related rights. So, I think very careful lang din tayo doon. So, to be safe, wala. Or, again, merong mga, how we wish we can give you the list of the available sources on public domain music. May mga public domain registries worldwide, especially in Europe. They are the more advanced one. Pwede kang kumuha doon ng music. So maybe you can try looking at it. Kung ulit-ulit naman itong mga webinars ganito, then maybe you can pick a set that you can play as background music for webinars like this.
Thank you po, Director Cuyo. Related po to public domain, we'd also like to ask a question on OERs. Diba? It was defined a while ago that there's OERs, they are public domain, and what Attorney Chuck mentioned a while ago was it was CC license.
Yes.
Is CC license actually, since Creative Commons is a corporation, is CC license like a brand? And para pong when you say Colgate toothpaste, because Creative Commons is a brand, it's a company, is CC license like that? Is the generic term actually open license? Is this correct? Because there is this there's generic term open license. Is this the same as CC license? Can you explain po?
I believe though, kasi yung term ng open license, it's actually
Software.
mas parang considered a subspecies of Creative Commons, specifically dealing with software, di ba? So ang best example dito ng open is yung Android project, di ba? Kasi yung Android project, di-launch yan na parang open software siya na ibig sabihin kahit sino pwede mag-modify or build upon the existing parang source code, di ba? Parang ganon. So hindi tama sabihin na pag sinabi mong open is equivalent na agad siya to CC license kasi magkaiba siya because definitely there are certain types of CC licenses na pag tinignan mo yung terms and conditions niya, hindi mo siya pwede sabihin na kapareho ng open source material or open source na software.
Kasi po, you're saying that yung sometimes the CC license can be even stricter. Is that what you're saying, Attorney Chuck? Yung that with CC license kasi there are six kinds and some of the conditions are
Yes,
stricter.
Yes.
Thank you, Attorney Chuck. Also, just to clarify rin po, Director Emerson, yung with regards to your presentation sa broadcasting, I believe the intent of DepEd is actually to go to radio and TV broadcast. Kaya that's why there's such interest. There's the intention to go into radio and TV broadcast.
Yes, to clarify that, then I think you can avail of the fair use provisions under that I have mentioned that has specific reference to broadcast. I think lang ang hindi magiging klaro at this point in the absence of an international standard are the rights of the broadcasters. So, meron naman nasa batas natin, I already stated that yung tatlong in the enumeration, but those are not parang in a way generic and are not yet very defined at the moment. So, magkaiba yung magiging role or yung response ni DepEd as a broadcaster and as the user of a work under the fair use. Kasi yung under the fair use provisions, DepEd will be in the character of a user, di ba? And broadcasting it to somebody else. Now, if DepEd wants to protect its work, then I think that has to be covered under the related rights provision.
Thank you po, Director Emerson. Another question po that we have relates naman po to the 4 factors of fair use. Just to clarify lang po that there are questions po that wants clarification on whether these 4 factors have to be present at all times for it to be available. Anyone po from our presenters can answer po.
The 4 factors test kasi actually originated in the US under the Campbell and Acuf-Gross case in 1994, which is 4 years before the code was enacted in 1998. And that's when we included those 4 factors test. So, pag titingnan mo the way it's used, and I think even in the Philippines, when the Supreme Court decided on the case of Pasita versus Habana, at dinetermine niya yung fair use, it applied it in its totality. So maybe in the process, one will cancel the other. In other words, mas magningibabaw yung reason na to. For example, it impeded or undermined the market and value of the work, may in some instances take a precedence over the other factors, but really the application of that by the court is to consider it in its totality. Kasi interplay yan eh. Like the nature of the work has something to do with the market value of the work. So, it's unavoidable that it's an interplay, although in the end, one of the factors may stand out against the others. But that's a determination for the court to make. And as per our discussion, that can also be a determination under the Bureau of Legal Affairs of the IPOFIL per the administrative procedures. So, pag may kaso ng copyright infringement, even our own Bureau of Legal Affairs does that to take it all in its totality.
Thank you po, Director Emerson. Related po, we have another question that was related to the broadcasting broadcasting part po of your presentation. Would it be okay po to have, for example, if, as I mentioned, DepEd may pursue radio and TV broadcasting if if images like clip arts from online are taken and used in these broadcasts, are there copyright implications, or are there copyright limitations that DepEd can apply?
Then I think if you are going to use section 184.1E, then it should be illustration for teaching purposes only. And therefore, you take into account the substantiality of the portion that you copied. So definitely, it will not have to be, because again, its only purpose is illustration. So I don't think DepEd would need to include an entire work just to illustrate and teach something. So dun lang siguro kayo very, in a way, careful because that would come into play. Because it says here the inclusion should be made by way of illustration for teaching purposes.
Thank you, Director Kuyo. But I would also like to further clarify that by saying that we would also need, do we also need, of course, to comply with fair use? Would it comply the situation, since it would be on a TV broadcast or radio broadcast, and this may be nationwide or region-wide? Would it comply with fair use?
Yung geographic, I think that one is a difficult issue. It's a difficult question, but I think you can embed in the process means and measures by which you can comply with the fair use provision. Because sabihin, you can embed, for example, rules doon sa broadcast nyo na yon to make sure that you fall closer to fair use rather than go further away from it. What those are, I do not have an idea. Maybe something like may rule kayo na dapat ganito. So even if all over the Philippines, hindi naman siya sabay-sabay, I don't know how you are going to do it. To embed therein measures by which you can come closer to the condition of fair use.
Opo, thank you po for that, Director Emerson. And I think the next question po, I think many teachers here would be interested in this kasi po marami po sa kanilang gumagawa, I believe nito, is that they in materials that they make references po to YouTube links. They indicate it in their materials. Naglalagay po sila ng yung link, the link itself. Is there any copyright implications when you do this?
Yeah.
Yes.
Attorney Chuck.
Yan. Kung ang ilalagay lang nila sa material ay yung link lang, 'di ba? So the student will be directed to the link on the page of YouTube itself. Mukha namang wala tayong issue to, 'di ba? As compared to, let's say, embedding the video itself doon sa material na, for example, kung online learning material siya, naka-embed na mismo yung video doon sa material. Doon medyo mas kumbaga mas ano pa yon, mas delikado as compared to merely providing links, 'di ba? Because in providing links, the creator of the learning material did not actually take the video, but instead merely directed students to YouTube, 'di ba? Para sa doon nila sa YouTube papanoorin, 'di ba? Which is kung tutuusin, pwede namang gawin 'yon even on their own time or kahit hindi ginagamit yung material. So, kung if it's an option between providing links and embedding videos, general rule, safer na mag-provide na lang ng links kaysa embed mismo yung video diretso sa material.
I agree with Attorney Chuck, and that may be the safer way to do it. Why? Because remember, the conditions and terms of the copyright owner may change. So pwede ngayon, free for all yon, but at certain point, and remember, kung nilagay mo na siya sa module mo or in your learning material, pwede na niyang na-violate at a certain point yung copyright talaga. Kasi ngayon, free niya. Let's say, for example, it allows others to make use of the video. But at some point, 3 months from now, ayaw na niya because nag-click. So, he wants to monetize his creative work. So, it's actually a safer way of doing it because by providing the link, sabi nga ni Attorney Chuck, pupunta sila mismo sa YouTube page or whatever page that is, and makikita nila na may restriction na pala, unlike when at the time that it was included in the module, there may be no restriction to it. I think that's the safer way to do it.
So you're saying po basically when you go po to the video, yung doon po papasok yung danger itself kasi you're not sure. Is that correct po, Attorney Chuck, Director Emerson?
When you include it in your module or in any digital material, so parang naka-embed, parang kinopya mo kasi siya eh. That's actually more dangerous because then there is an actual violation of the economic right of the copyright holder. Unlike pag nililink mo kasi dan, as explained by Attorney Chuck, you actually do not violate kasi you didn't download eh. You didn't share it also. Unlike pag nag-download ka, in-embed mo, inilagay mo talaga siya, then there is downloading, there is also communication to the public. So it becomes more complicated as a process.
Opo. I understand po, yeah. So yun nga po, it becomes complicated po because of you don't know what, if for example if you're gonna give it to a learner, a student, it becomes complicated na. You don't know what restrictions that site, that link will have or what. Another question po namin is also with regards to how teachers use materials po in teaching, is that relates to music po, I think this happens po sa mga probinsya rin, especially they convert it, they use the melody of the music and they siguro naglalagay po ng yung ibang language po natin sa regions, sa divisions. Although we do have our copyright limitations po, pero what are your thoughts po on this? When teachers convert, they use the melody lang, they convert songs using only the melody, and they change the lyrics. Let's say some will translate or maybe provide a different lyric.
Yes, that's actually a form already of adapting the original work, di ba? Para siyang, kumbaga, yung original music, original kanta, minodify mo na or inadapt mo na, di ba? Siguro ang perfect example dito would be yung during campaign season, di ba? yung mga politiko na nangangampanya. Usually, ang ginagawa nila, yung mga campaign jingles nila, di ba? Ginagamit nila yung melody ng mga sikat na kanta at the time, pero yung lyrics babaguhin in such a way na para ikampanya yung sarili nila, di ba? So, parang ganun parang ganun yung nangyayari dito. This is already modifying or adapting a work, so it's already, we're already making a derivative work, di ba? Based on the original song. So again, going back to the general rule, pag gagawa ng derivative work, kailangan ideally na nagpapaalam dun sa copyright owner, dun sa kanta, na before mo siya i-modify.
Thank you, Attorney Chuck. And balik lang po ulit tayo dun sa broadcasting because a question came up regarding it again po. And I think you have actually answered this already. Maybe you can reiterate po. Yung parang you mentioned something about erasing the content after the broadcast. Meron pong specific number of may period po kayong mention. I believe you mentioned this, but maybe for purposes po of clarification, you can mention it again po, Director Emerson.
Under section, I think that's F. Ang F is more recording of a broadcast. Okay, so may broadcast, somebody recorded it in the school or from the school. Sabi doon, it's okay to do that. I think ang tawag nila dito is in other jurisdictions, they would call this the off-air recording. So, nag-record siya. Yung teacher, for example, made a recording of a broadcast. And I think that's okay under F. But ang proviso doon is that such recording must be deleted within a reasonable period of time. Sa batas natin, sa 184.1, walang nakalagay na time. So, ang sinasabi ko po ay dapat i-cover ito ng implementing rules and regulations. And I explained earlier na kung pagbabasehan natin yung model copyright law that the WIPO came out with in 1976, ang nakalagay po doon, if I'm not mistaken, I'm not too sure about this, but I think it's 7 days.
This is recording po,
Yes.
Director Emerson. You're talking about recording. Kasi po, I believe the question actually pertain to broadcasting. Siguro na confused lang po yung yung.
So kung 184.1E, then there is no provision there for a period within which it should be deleted, but the condition there naman is will affect substantiality, meaning ang reason kasi doon, ang purpose nun is dapat in-include siya sa isang broadcast para mag-illustrate during a teaching session or a learning session. So, ang apektado naman doon is how much of it can you actually include, substantiality. Yung F kasi, kung recording siya, ang sinasabi dito, you can actually record the entire broadcast. However, you have to delete it within a certain period. So magkaiba siya. Now, if the purpose is for teaching purposes, illustration for teaching purposes, there is no period within which you're required to delete that. But again, it will affect gaano kadami ang pwede mong i-include. Yung substantive portion of the work that you can include there.
Thank you po, Director Kuyo. And siguro po, this might be this might be po a follow-up question regarding that. Can the recording be done po outside of school if teachers are working from home? Would it still comply po with the conditions?
I think it would, for as long as that is sanctioned. I was looking actually at the other provisions in the copyright law of other jurisdictions. And I think we should be able to come out with a decision. Ang ano lang doon is dapat it's a sanctioned activity by the school.
I'm sorry, for as long as it's sanctioned by the school po. Kahit po nag-work from home si teacher, pasok
Yeah.
po siya sa ating
I
copyright
think that should
limitations.
come within that copyright exception po. But
Okay.
to be clear lang, do not quote me on this. It's my of at the moment, since it's not an official IRR. It's a personal opinion on this particular provision. Kasi wala naman tong nakalagay that it does not apply if the recording is made in schools. It's really how you interpret yung ang haba kasi nitong clause na to eh. But it means lang na the recording made in schools means that it's for purposes of a school activity. And that the broadcast was also intended for the school. So I think within that interpretation, it should okay lang, I think, for this. But to be safe, let's wait for the implementing rules, for of which DepEd can also comment.
Thank you po. Yeah, we are actually at DepEd po, we look forward to seeing po yung implementing rules, and we look forward to taking part po in
Yes.
in
And I'm
talking about how we
clarifying that lang because under the IP code, it's actually the Director General who has the rule-making power. It's not actually the director, it's not me that has the rule-making power, it's the Director General. So what we can do is to craft an initial draft of the implementing rules and regulations and consult it with the public and stakeholders, and then submit it to the Director General for his approval or consideration.
siguro po as a final question, at medyo nakakarami na po tayo, and we, as much as we would want to answer all of the questions po, talagang it would a very impossible feat to do at such a limited time. So thank you po again to our presenters for answering all of our questions. Siguro po our last question for this webinar would be, ano po yung I think this is done frequently po, yung screenshot po yung picture online. Ano po ang nito, ang implications in terms of copyright? Pwede niya hubang for example, there's a material online that someone saw, screenshot na. Does that mean pwede niya nang gamitin sa work niya or hindi pa rin ho? Ano po ang implikasyon nito in terms of copyright?
Yeah, who wants to answer? Sige, I'll start na lang. I think ang implication niyan is depending again on your assessment of the copyright in the work, whether there is a subsisting copyright in the work. So if there is a subsisting, regardless kung in-screenshot mo lang, because even a digital reproduction or a digital yeah, tama. That is considered as a reproduction when you take a digital shot of the work, and therefore it's a violation of one of the economic rights of the author. Ngayon kung it's a free source, it's a public domain work or a CC license work, CC-BY, then okay din lang na okay siya na even if you decide to reproduce it via taking a screenshot of the work. So at the end of the day, it will have to be, it is dependent on the nature of the work that is being screenshot. Because a screenshot, a scanning, whatever, kay digital yan, kay physical, Xerox yan yung alam natin. But even a scanning or a digital shot is considered a reproduction of the work.
Yes, agree. All right, to add to that, siguro, am I still on? Is my mic on?
Yes,
yes,
Yes.
When we when we consider the use of a copyrighted work, we should always look into the the seven economic rights of a copyright holder. Like that one is a rep, affects the right of reproduction of the copyright holder. And when you screenshot, usually you share it, diba? To show it to others could be like could violate the right to display or performance of the copyright holder. So whenever you do things like you're producing things that are copyright protected, tignan nyo muna if they violate any of the economic rights, and then go to the fair use. It's the purpose of your doing the screenshot, of making the screenshot. Is it for a legitimate purpose, or will it affect yung amount that in-screenshot mo? Does it is it substantial that will affect for example, if you share it to many people, will it affect the potential market value of that particular work, and so on and so forth. So everything is examined on a case by case basis.
Thank you, Attorney Jeremy. Thank you for that. Yeah, that's basically how it is with using copyright limitations and fair use. It's a case by case basis po talaga. Talagang ganun po siya ini-examine, ini-evaluate. So again, thank you po sa Director Emerson, Attorney Chuck, uh, Jeremy. Please stay on while I turn you over to our main moderator. Thank you very much po in behalf of DepEd.
Thank you.
And we hope po, we really look forward po. We really look forward po to further expanding our partnership with IPOFIL. Thank you po very
Thank
much.
you.
Thank you everyone.
Maraming salamat, Attorney Art, Attorney Chuck, Attorney Jeremy, and Director Cuyo for that discussion. Now, to formally express our thanks to our dear speakers, we will award the certificates of appreciation. Let me read the citation. Republic of the Philippines Department of Education presents the Certificate of Appreciation to, as a resource speaker in the webinar on Copyright Management of Learning Resources held on July 24 and 27, 2020 via Microsoft Teams, given this 24th day of July 2020. Signed, Diosdado M. San Antonio, Undersecretary for Curriculum and Instruction, and Attorney Josephine G. Maribohok, Undersecretary for Legal Affairs. First off, we award the certificate to Attorney Ezekiel Chuck D. Valerio.
Thank you.
May palakpak.
Yung palakpak na ba na yan ay hindi covered ng copyright rules. Anyway, we award the same certificate of appreciation to Attorney Jeremy John C. Bayaras.
Thank you.
Finally, we award the certificate of appreciation to Director Emerson G. Cuyo. Maraming salamat po ulit, and as Attorney Art has noted, we look forward to our continued partnership in this endeavor. And that does it po for day one of the webinar on copyright management of learning resources. We will see you po on day two. Maraming salamat.
Thank you.
Thank you.
Okay, thank you. Maraming salamat.
Thank you po. Thank you po.